Going to be a little echoey. That's better though. I can hear, we can live with that, I think, if it's very low volume. Okay. Well, good morning, everybody. Let's get started. Have you started recording it, moderator?
Yes, we have.
We have. Okay, great. Well, good morning, everyone. Before we start, I would like to make one quick announcement. It is Jessica Olney's birthday today, and we will not be singing happy birthday because this is the Dental Board of California, but we wish you a happy birthday. Trust me, Jessica, you do not want to hear us sing. Well, good morning, everyone. Thank you for joining us for this Dental Board of California meeting. I am Dr. Alan Felsenfeld, and I serve as the president of the board. Today is Friday, February 10th, 2023. This board meeting is being held in person with additional public participation through WebEx. For all those who wish to participate online, please log on to the WebEx website provided on the posted agenda for this meeting. Instructions to connect to the meeting are provided on the agenda. The preferred audio connection is via telephone conference and not the microphone and speakers on your computer. The phone number and access code will be provided as part of your connection to the meeting. During each call for comments from board members and speakers, we will ensure that all comments that can be accommodated are heard before proceeding with the agenda. This is an official business meeting of the Dental Board of California. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action or on any agenda item. The DCA moderator will explain the process for providing public comment shortly. For individuals participating via WebEx, when called upon, the moderator will give the individual permission to unmute themselves, and they will have 2 minutes to make public comment. The moderator will audibly announce when 30 seconds remain to conclude the public comment. After the 2 minutes have lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. Depending on the number of people who would like to testify on a particular agenda item, a total time limit may be imposed. We ask all speakers to please stay on topic and not repeat testimony already provided. If you agree with the testimony already provided, just please state your name and that you are in support of any comments previously provided. I would now like to ask the DCA moderator to explain how the public comments will be taken during the meeting.
Thank you. This is the moderator. For today's meeting, when the board president opens for public comment, members of the public who would like to provide public comment at our location in Sacramento can approach the table and microphone at the front of the room. For those joining via WebEx, we will be utilizing the WebEx question and answer feature to facilitate public comment. When the board reaches the appropriate point in the agenda, the Q&A feature will be turned on. Members of the public can indicate that they'd like to make a comment by typing the phrase comment into that question box. And you find that typically in the lower right-hand corner of your WebEx screen. I will then call on each individual, give each individual a permission to unmute their own microphone. You'll have 2 minutes to make your comments. I'll give you a 30-second warning. And at the conclusion of your time, your microphone will be muted, and we'll move on to the next member of the public who has a comment. Please note that this Q&A feature is being used only as a means for members of the public to represent that they'd like to make a verbal comment. This is not a means to ask questions of the moderator or board members. Questions submitted using this feature will not be answered. And when making your comment, please make sure that the comment is directed at the host or everyone in the dropdown. While you are free to express criticism or negative views, for the sake of the members of the public participating on the call, please do not use profane language when making public comments to the board. We will provide a brief reminder of this approach, and there will be a slide shown at the time. And that's back to you, Dr. Felsenfeld.
Thank you. I would like to call the meeting to order and ask the board secretary to please call the roll.
Good morning. This is Dr. Lilia Larine. I'm board secretary, and I'll call the roll. Chan?
Chan, present.
Chan, present. Felsenfeld?
President Felsenfeld, present.
Present. Forge?
Forge present.
Forge, present. Larine, present. Mackenzie?
Mackenzie here.
Mackenzie here. Medina?
Medina present.
Medina, present. Molina?
Molina present.
Molina, present. Olage?
Olagi present.
Olage, present. Thakur? Thakur, present. And
Pacheco
you?
present.
Pacheco? Present, sorry. Thakur, present, and you?
You present.
Thank you. We have a quorum, Mr. President.
Thank you, Dr. Secretary. We will now move on to Agenda Item 20, the President's Report on Closed Session Items. The board heard an update on pending litigation. We will now move on to Item 21, the Dental Assisting Council Meeting Report. Ms. Tracy Reed Espinoza, would you please come forward and give your report?
Good morning. Thank you, President and Board.
Turn the mic on, please.
It is
Move
closer.
then. Closer.
Okay, there we go.
Thank you.
I'm here to present a brief update of our DAC meeting yesterday. First agenda item was delivered by Mrs. Parks. It's an update on the dental assisting exam and statistics. No actions needed. Second was review of dental assistant licensing and statistics. No actions needed. Third is an update discussion on the status of the survey for registered dental assistants for extended functions, administering local anesthesia and nitrous. This was a robust conversation. The survey that was completed, we would like to present to the board. Next, all the results were briefed by Jerry Fowler and myself. We were very pleased with the results that were given to us. The majority of the RDA EFs and the dentists that supervise EFs supported the expansion of the scope of practice to include local anesthesia and nitrous and to receive specialized training. Next was the update on discussion and research of the dental auxiliary certification education requirements and review of applicant status, regulatory board approval of registered dental assistants and registered dental assistants in expanded functions, educational programs, courses for potential amendments. This is going to be a continued review by the Dental Assistant Council at this time. Next was a discussion on the possible action for legislation 1715. At this time, we have moved forward with a proposed amendment. The move was recommended to the board, including the board a sunset review report to revise legislation proposed in the amendment of the BPC section 1750 to add new subdivided C to clarify infection control course requirements, renumber the subdivision and amend the subdivision D to clarify the timing and completion of other requirements of course. At this time, this concludes my review of the DAC meeting. Is there any questions?
Thank you, Ms. Reed Espinoza. Very nice. Do we have any board comments? Seeing none, are there any comments from the public in the room? Once again, seeing none. Thank you, sir. Are there public comments from individuals participating via WebEx? Will the DCA moderator please facilitate the lines for public comment?
Certainly. We've opened up the WebEx Q&A feature to facilitate public comment. If you'd like to make a comment on the report, you may look for the question mark, tap that, type the word comment into the text box and click send. And each speaker will have 2 minutes to speak with a 30-second warning. And attendees may also raise their hand by clicking on the hand icon, typically down at the bottom row of the WebEx screen or behind the 3-dot other options if you're on a mobile device. I do not see any requests for comment. Shall I close the public comment feature?
Yes, please.
Thank you.
I think you're done.
Thank you.
Thank you very much. We're going to move on to agenda item 22A, discussion and possible action on legislative proposal to amend Business and Professions Code Section 1635.5 regarding licensure by credential requirements. I'm going to ask Ms. Regali to come up and tell us all about that.
Thank you, Dr. Felsenfeld, and good morning, members of the board. My name is Paige Regali, and I will be presenting agenda item 22A, which begins on page 154 of the meeting materials. This memo lays out a legislative proposal for statutory amendments regarding the licensure by credential pathway, which we refer to as LBC. LBC is one of 5 pathways to licensure for dentists. The LBC pathway is unique in that the applicant may qualify for licensure based on an out-of-state license. This is the only pathway that does not require a degree from a dental school approved by the board or by the American Dental Association Commission on Dental Accreditation, otherwise known as CODA. Additionally, this pathway does not require an examination. In 1996, the California State Legislature Joint Legislative Sunset Review Committee recommended the LBC pathway to increase the number of dentists eligible to practice in California, especially in underserved areas. Various issues have been brought to board staff's attention, which have been identified in the legislative proposal, which begins on 161 of the meeting materials. Board staff have proposed various changes to the statute to help streamline the application process for LBC and to increase access to licensure in California for dentists. The issues and proposed amendments are as follows. Currently, the LBC pathway requires an applicant to have a current dental license issued by another state that is not revoked or suspended or otherwise restricted. Otherwise restricted is not defined in statute or regulation. Board staff propose amending BPC section 1635.5 to strike out otherwise restricted and include additional clarifying language regarding the license status and disciplinary actions. This pathway also requires the applicant to provide proof of active clinical practice for at least 5,000 hours in 5 of the 7 consecutive years immediately preceding the date of the application. Board staff propose amending BPC section 1635.5 subdivision A3 to include language to clarify the minimum clinical practice hours needed and to clarify that the hours must be completed in a state, district, or territory of the United States within the preceding 5 years. Currently, applicants who have completed a CODA-approved residency program, regardless of the length of the program, are granted 2 years credit towards the 5-year requirement for clinical practice. Board staff propose amending BPC section 1635.5 subdivision A3A to specify that residency credit will be awarded at 1,000 hours per year up to 2,000 hours for a completed residency training program approved by CODA. This pathway also allows an applicant who does not meet the minimum clinical practice requirement to enter into a 2-year contract with a California board-approved dental school or to practice in at least one primary care clinic that meets the requirements outlined in BPC section 1635.5, subdivision A3B. Board staff propose amending BPC section 1635.5 subdivisions A3B and C, which relate to the contracts, to define the minimum hours per week as 40 hours per week to teach or practice dentistry under the faculty contract and 32 hours per week to practice dentistry under the clinical contract. These definitions are consistent with other sections in statute. Amendments are also proposed to BPC section 1635.5 subdivision E to clarify the process in which an applicant does not fulfill the 2-year contract under subdivisions A3B or A3C. The final proposed substantive amendment is to clarify the requirement that the applicant provide proof that they have not failed a licensure examination in the 5 years preceding the application. Board staff propose amending BPC section 1635.5 subdivision A6 to provide that if an applicant has subsequently passed an examination for licensure, the prior failure shall not make the applicant ineligible under this section. Board staff is asking the board to discuss and consider the above described legislative proposal. If the board approves of the legislative proposal, the board is asked to include in the board's next sunset review report a recommendation to amend Business and Professions Code section 1635.5 to clarify the licensure by credential application process and requirements. I'm available for questions. Thank you.
Thank you. Do we have any board member questions or discussion?
have
Dr.
a question.
Molina?
So, in terms of if they have, a contract, to either practice in a, clinic or to teach in a school, that will be something that will be, done ahead of time?
So currently, we allow contracts as a sub-pathway to the licensure by credential pathway for licensure. The only changes we're making to those is that clarifying what happens if a contract is not fulfilled and defining the actual hours required for full-time in both settings, the faculty contract or the clinical contract. As far as, they have to obtain a contract when they apply for licensure.
And then what happens if they lose their contract in the middle?
So if they lose the contract, we currently allow them to change to a new contracted place to fulfill the 2-year requirement.
Thank you.
Or if they don't?
Or if they don't, then those are the changes that we're making, that the contract and the license will be considered canceled or voluntarily surrendered, which wouldn't impose discipline.
Thank you. I do have a question about the 40 versus 32.
Yes.
You knew that was coming. You say 32 if you're in clinical practice, 40 if you're in academics. Why the difference?
So when we were going through it, it was mostly because our loan repayment program and other programs, when they define clinical practice in a clinical setting and direct patient care, it defines full-time as 32 hours per week. For the faculty contract, because it allows you to teach and to practice clinically, we allowed 40 hours per week because there's the other administrative functions, the teaching functions, as well as patient care.
Okay. Are there any other board member comments? Thank you. Are there any comments from the people here in person? I think Tuka is coming up. Thank you.
Hello, Tuka Zokai with the California Dental Association. I know there's been some questions about clarification of the pathway and the 5,000 hours, but I also wanted to bring up again that Dr. Morrow previously advocated during his tenure as a DBC member to lower the licensure by credential threshold to 3 years from 5 years, which is in parity with several other states and substantially increases portability. Is the dental board still interested in doing this? Is it something that's been under discussion? I wanted to bring it up.
Thank you. Ms. Regali, did you want to speak to that? Or-
If I'm able to respond?
Please.
Yes. So we removed the year requirement. So what happened is with the new proposed amendments, there would no longer be a requirement to practice for a minimum amount of hours as well as a minimum amount of years. With the new amendments, it would just be a minimum amount of hours over a 5-year period. So they can't have practiced 10 years ago and use those hours to qualify. It has to be relevant practice, which is 5 years preceding the date of the application. Now we only require 5,000 hours, which we don't say can't be done in 3 years. Technically, if you're working full-time, it's around 2,080 hours per year that a dentist would earn clinical practice time for. So essentially, they would be able to qualify for licensure in California under this pathway in 2 to 3 years, at minimum. So it is allowing more access to licensure.
Thank you. Any other public comment from people in the room? Seeing none, is there any public comment from people who are participating via WebEx? Will the DCA moderator please open up the microphones for comment?
Certainly. We've opened up the WebEx Q&A feature to facilitate public comment. If you'd like to make a comment, you can click on the question mark icon, typically in the lower right of your WebEx screen. Type the word comment and click send. Anyone may also raise their hand by clicking on the hand icon. Are there any comments? I do not see any requests for comment. Shall I close the Q&A feature?
Thank you. We're going to need a motion for action. Anybody want to make that, Dr. Lirin? Okay, thank you for the motion. Dr. Chan, you're seconding. Thank you. Dr. Chan seconds. Once again, we'll go through the public comment because I have to do that this way. Any additional board comments? Thank you. Any public comment, additional public comment from the people in the room with us? Thank you. And DCA moderator, please open it up for public comment one more time.
Certainly. And as a note, we did not hear the exact motion, but I assume there were no substantive changes. If anyone would like to make a comment on the motion, you can look for the question mark icon, typically in the lower right of your WebEx screen, type the word comment and click send, or you may raise your hand by clicking on the hand icon. And I do not see any requests for comment. Shall I close that feature?
Thank you, Board Secretary. Close that down, and thank you, Board Secretary. Please take the vote.
The motion is as stated, and I'll call the roll. Dr. Chan?
Chan, aye.
Chan, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Larin, I. McKenzie?
Kenzie, yes.
McKenzie, yes. Medina?
Medina, aye.
Medina, I. Molina?
Molina, I.
Molina, I. Olage?
Olagi, aye.
Olage, I. Pacheco?
Pacheco, I.
Pacheco, I. Thakur? Thakur, I. You?
You, aye.
You, I. Motion passes.
Thank you very much. We will now move on to agenda item 22B. Once again, Ms. Regali, we're going to talk about a discussion and possible action on legislative proposal to amend Business and Professions Code Sections 1701.5 and 1804 regarding fictitious name permits and dental corporation name.
Yes, thank you. The next agenda item, Paige Regali again for the record. The next agenda item I will be presenting is agenda item 22B, which is regarding a discussion and possible action on a previously approved legislative proposal that board staff have made additional changes to. The initial legislative proposal to amend BPC sections 1701.5 and 1804 regarding the fictitious name permits and dental corporations was heard at the August 2022 meeting. And it was adopted as written. After further consideration and review, board staff have made additional amendments to the approved text in order to clarify the language and make the processing of the applications more efficient. The meeting materials include a redlined version on page 170, which shows the changes made from the version approved in August of 2022. The clean version found on page 173 shows the newly proposed text. Just to highlight the new amendments that we've made, I will go ahead and list them out for you.
Please.
So previously, board staff proposed that the permit applicant should specify the name, license numbers, and contact information for each dentist engaging in practice under the fictitious name. This would have required the above information for all licensed dentists engaging in practice at the specified location, including any contracted dentists. The new amendments only require the information for permit applicants. This amendment will allow board staff to receive relevant information regarding the permit applicants without adding workload that would result from requiring information for all dentists at the location, including any contracted specialists. Previously, board staff proposed changes to the application process to require information on all officers, directors, and shareholders of an association, partnership, group, or dental corporation as applicable, because an FMP applicant can be an entity rather than an individual. Board staff believe this information is not relevant to the FMP application because dental corporations can have as shareholders other licensed professionals who are not licensed dentists and who, outside of a dental corporation, cannot own or operate a dental office. This language was removed in the new amendments because this requirement adds additional paperwork that is not necessary when applying for a permit to operate and advertise a dental practice under a fictitious name. Additional clarifying amendments to the statute are requested to resolve confusion over the active, unrestricted license status of individuals practicing at the location who are not FNP applicants. Board staff previously proposed amendments to require that any additions or departures of dentists engaged in practice under the fictitious name be reported to the board within 30 days of such addition or departure, which is consistent with the licensee change of address reporting requirement under BPC Section 136 Subdivision A. The newly proposed amendments maintain the same reporting requirement for departing dentists. However, any additions would now require a new application for an FNP. This would allow board staff to evaluate the additional dentists who wish to engage in practice under the fictitious name for compliance with the FNP application requirements. Board staff is asking the board to discuss and consider adding the new proposed amendments to the previously approved legislative proposal. If the board approves of the attached additional amendments in this legislative proposal, the board is asked to include in the board's next sunset review report a recommendation to amend Business and Professions Code 1701.5 and 1804 to clarify the fictitious name permit application process and dental corporation name requirements. And just as an added note, we did not make any further changes to 1804.
Thank you. Is there any board member discussion about any of these issues? Dr. Chan?
Good morning, Paige.
Good morning.
I'm not entirely clear on page 168, and the question is about the corporations, dental corporations. And I understand the variable about having to own a practice has to be a licensed dentist. And yet if we delete the dental corporation variable in there because some shareholders are not dentists or licensed dentists, how does one track the dentist within that fictitious name that's applied to that practice?
So the way that it works currently is that you can apply as a corporation, as an individual, as a partnership, or an association for a fictitious name permit. All dentists are required who are going to be owners, operators of that specific dental office. They're required to list their names and license numbers, which we track. So the additional amendments that were previously made was to include information relating to all shareholders or officers of a corporation, which can be a varied amount of professionals. So at this time, they're not relevant to the application process in that the purpose of the FNP is to be able to know who is owning and operating and responsible for what's happening at the dental office. So having, listed RNs or other professions that can all be a part of a dental corporation up to 49% of the shareholders, they wouldn't be able to be listed or tracked in our system anyways on the permit.
So the latter part is not relevant, and the other way of tracking is through the licensed owners.
Correct, yes.
Correct. Thank you.
Thank you, Dr. Chan. Any other board member discussion? Okay, I'd like to make the motion then to bring this in. I'd like to move that we add the new proposed amendments to the previously approved legislative proposal and include this in the board's next sunset review report, include a recommendation to amend BPC Sections 1701.5 and 1804 to clarify the FNP application process and dental corporation name requirements. Dr. Chan, I think, is going to second that. Is that correct, sir? Thank you. Is there any further board member discussion? Seeing none, is there any public comment from those of us in the room? Seeing none, moderator, would you please facilitate public comment for those on WebEx?
Certainly. We've opened up the Q&A feature to facilitate public comment. If you have a comment on the motion, you can click on the question mark icon, type the word comment and send, or you can look for the hand icon, click that to raise your hand. And if you are on a mobile device, the hand icon may be behind the 3-dot other options.
No comments?
No comments at this time.
Thank you. You may let us come back to work here. The motion, I will restate the motion then. We're going to vote on, we're ready to vote, and the motion is to add the new proposed amendments to the previously approved legislative proposal and include in the next sunset review report a recommendation to amend BPC sections 1701.5 and 1804 to clarify the FNP application process and dental corporation name requirements. Madam Secretary.
The motion is as stated. I'll call the roll. Chan,
Chan, aye.
Chan, I, Felsenfeld,
Felsenfeld, aye.
Felsenfeld, I, Forge,
Forge, aye.
Forge, I, Larin, I, McKenzie,
Kinsey, yes.
McKenzie, yes, Medina,
Medina, aye.
Medina, I, Molina,
Molina, I.
Molina, I, Olage,
Olagi, I.
Olage, I, Pacheco,
Pacheco, I.
Pacheco, I, Thakur, Thakur, I, you,
You, aye.
you, I. Motion passes.
Thank you, Madam Secretary. Thanks, Ms. Regali. We now move on to agenda item 22C, discussion and possible action on legislative proposal to amend Business and Profession Code Section 1750 regarding unlicensed dental assistant course requirements. Good morning, Mr. Bruggeman. Please take the lead.
Good morning, President Felsenfeld and board members. The item that I'm going to be discussing today is the same legislative proposal that the DAC considered at its meeting yesterday. The specific changes that board staff are recommending for consideration deal with what is currently Business and Professions Code, Section 1750, Subdivision C. And that has to deal with the current requirement, which I'll read as follows. The employer of a dental assistant shall be responsible for ensuring that the dental assistant who has been in continuous employment for 120 days or more has already successfully completed or successfully completes all of the following within a year of the date of employment. And then the section subdivision proceeds to list the current course requirements. Now, in 2021, the Dental Assistant Council and the board approved a legislative proposal that amends other provisions of section 1750. And so the specific proposal that we are making is going to do some reorganizing and amendments of the section so that things would read a little differently. The specific proposal starts on page 179 of your meeting materials. And the changes that we're bringing to the board today are highlighted. So the additions that we are asking to be made to the law are going to be found in yellow highlight and underlined. The language that we are asking be stricken is going to be found in yellow highlight and strike through. I bring this up simply because we're amending a previously approved proposal. And if the board does not proceed with the amendments that we're making today, the rest of the proposal that was previously approved is still going to go forward as a recommendation into the board's sunset review report. So the specific changes that we're making here would be to essentially strike the requirement, the 120-day requirement from the current law, so that the employer would then be responsible for ensuring that the dental assistant who has been employed continuously or on an intermittent basis by that employer for 1 year from the date of first employment has already completed or successfully completes all of the following courses within 1 year of the first date of employment. This and the section continues to list the respective courses that are required. You'll note that there is a strike through through the infection control course. That is because that is now in what is subdivision C in the legislative proposal. We are not exempting the course from consideration here. It is still addressed within the language that we are advancing to the legislature. So in the specific issue that is related to the elimination of the 120-day calendar requirement, and this would eliminate the confusion that has been expressed to board staff through various stakeholders concerning when dental assistants are to be counted or not counted with consideration for course completion. At the end of our memo on page 178, we have proposed motion language. Option 1 would be to accept the legislative proposal as we have recommended. Option 2 would provide for the board to make any other changes that they think would be appropriate at this time. And as I indicated before, if the board opts not to move forward with this proposal, the language that is in this proposal but not highlighted would still move forward into the sunset report.
Thank you. Is there any board member discussion? Seeing none, we will need a motion. Anybody interested in doing a motion?
I can do.
Thank you, Dr. Loren.
Option one.
You have to read it twice now. Recognize
Okay.
that. So, okay,
Really?
go
This
ahead.
is just- The motion is to include the new proposed amendments in the previously board-approved legislative proposal. Move to recommend to the board inclusion in the board sunset review report of the revised legislative proposal to amend BPC Section 1750 to add new subdivision C to clarify infection control course requirements, renumber the subdivisions, and amend subdivision D to clarify the timing of the completion of the other required courses.
Thank you. Just for clarification, the parenthetical part of this doesn't have to be in the motion. It's just the non-parenthetical part. Is that what you were saying? Thank you. I knew that. Is there any further board member discussion? Ms. McKenzie? Oh, you want to second it? Thank you. All right, we have it seconded. Further board member discussion? Seeing none, it's time to put it out to the public. Anybody in the room want to make a comment on this? Seeing none, will the DCA moderator please facilitate public comment via WebEx?
Certainly, if anyone has a comment on the motion, you can look for the question mark icon, click that, type the word comment and click send, or anyone may raise their hand by clicking on the hand icon. Are there any requests for comment? I do not see any requests for comment. Shall I close the public comment feature?
Thank you. Please do that.
Thank you.
Will the secretary please take the roll and read the motion again?
Read it again, okay? I
Thank you.
will. Move to recommend to the board inclusion in the board sunset review report of the revised legislative proposal to amend BPC Section 1750 to add new subdivision to clarify infection control course requirements, renumber the subdivisions, and amend subdivision to clarify the timing of the completion of the other required courses. I will now call the roll. Chan?
Chan, I.
Chan, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Ford, aye.
Forge, I. Larin, I. Larin, I. McKenzie?
McKenzie, yes.
McKenzie, yes. Medina?
Medina, aye.
Medina, I. Molina?
Molina, I.
Molina, I. Olage?
Olagi, I.
Olage, I. Pacheco?
Pacheco, I.
Pacheco, I. Thakur? Thakur, I. You?
You, aye.
You, I. Motion passes.
Thank you, Madam Secretary. We now move on to agenda item number 22D, discussion and possible action on legislative proposal to modify statutes related to general anesthesia and sedation permits. Mr. Bergman, please continue.
Thank you, President Felsenfeld. In the time since SB 501 has passed, the board has approved a total of 4 legislative proposals that would address various issues related to cleaning up the legislation, clarification of various provisions and dates. If you look in your BINA materials on pages 182 and 183, we have a chart that broadly summarizes those proposals, including the points in which the board had previously approved those items. In going through them and preparing for the sunset report, we are going to offer a consolidated proposal that addresses items that have already been approved by the board. In addition, there are certain items that have been rendered moot by the passage of time and some additional items that have come up in review by board staff and subject matter experts. So the proposals that the board has approved to date have addressed the following basic areas. We have provisions to address the possible gap between the effective date of SB 501 and the implementation of the regulations for SB 501. Since the regulations for SB 501 have been implemented, the language in those proposals that would change the effective date of the bill are no longer necessary. Proposals have also addressed the fees for the various permits and corrected the names of the respective permits on the fee schedule. Additionally, there are some ambiguities in the language concerning physicians and surgeons seeking general anesthesia and sedation permits that are issued by the board. And a proposal was approved to clarify that language that would include osteopaths and would eliminate review by the medical board from the approval process for those permits. Additionally, we identified outdated language in the oral conscious sedation for adult certificates and have language in our proposals to eliminate those references and to eliminate a pathway that prevented the accumulation of 10 cases prior to 2005, which at this point is no longer, in our opinion, necessary or realistic. Additionally, prior legislative proposals can address continuing education requirements and expiration dates for the pediatric mental sedation permits. And the effort there was simply to make sure that the language in respect to those permits is consistent with the language concerning the other anesthesia and sedation permits. We have some additional changes to recommend. There is concern about the physical presence requirements. If you were to review the language in law about the general anesthesia permits in comparison to the moderate sedation permits and the pediatric mental sedation permits, they are not consistent in the requirements that those ordering or administering the anesthesia are to be present within the facility when the patient is under sedation. And we've listed the specific language as it's currently written, starting on page 183 of your meeting materials. The proposal would conform the physical language requirements across all of the permit types, and the specific language that we would recommend using in each of the respective sections can be currently found in Business and Professions Code section 1674.31 subdivision B. Additionally, there have been confidentiality concerns raised and involved in connection with the submission of patient case information. As you may be aware, in certain permits and certain endorsement requires the submission of case information showing that the applicant has performed a certain amount of cases of sedation. Depending on the permit and the endorsement type, there may be other requirements there. Board staff have run into situations where applicants have been prevented from providing that case information based on concerns from the relevant institutions about the confidentiality of the patient information. And so we are recommending that in the legislative proposal, specifically adding language to Business and Profession Code section 1646.2 subdivision C2 and 1647.3 subdivision D2, modeled on other confidentiality language within the Business and Profession Code that would make these case records submitted to the board expressly confidential and bar their disclosure. And we believe that this would help alleviate those concerns expressed by institutions and make it easier for applicants, specifically those that are approaching graduation, to apply for these permits. And then finally, if we were to, in review of the pediatric minimal sedation requirements, the previous permit for this particular type, the oral conscious sedation for minors permit, had a requirement to take a physical evaluation and medical history prior to the administration of the oral conscious sedation for minors. In review of the statute, we have determined that those requirements were left out, presumably inadvertently, from SB 501, and we're making a recommendation to the board to include such language in connection with the pediatric minimal sedation permits. That summarizes the proposed changes and the consolidation of the previously approved legislative proposals. As has been custom, we've got two suggested motion languages to consider. One, if there are no additional changes that the board wishes to make at this time, and then the other, if there are changes that the board wishes to make. At this point, I'd open it up to questions.
Thank you. Is there any board member discussion or questions? Are there any questions from the board? Seeing none, then I will take the onus of reading a resolution in, or a motion in, and you're going to have to repeat this, and it's there for you. I move to submit to the California State Legislature and the Board of Sunset Review Report a recommendation to add section 1646.12 to Article 2.75 and sections 1647.35, 1647.36, and 1647.37 to Article 2.87 and amend sections 1641.1, 1642.2, and 1649.9 of Article 2.75, Sections 1647.2 and 1647.3 of Article 2.84, Section 1647.18, 1647.19, 1647.20 and 1647.22 of Article 2.86, Sections 1647.35 and 1647.36 of Article 2.87, and Section 1724 of Article 6 of Chapter 4, and repeal Section 2079 of Article 3 of Chapter 5 of Division 2 in the Business and Professions Code. Is there, that's the motion. Is there a second? Dr. Chan, I believe, Dr. Chan was first. Dr. Chan, you're going to second that. Thank you. Is there any further board member discussion? Seeing none, we're going to open that up to the public. Members in the room, are there anybody who want to come up for that? Seeing none, let's open up for the WebEx users. DCA moderator, please facilitate the WebEx comments.
Certainly. We've opened up the WebEx Q&A to facilitate public comment. If you have a comment, you can tap the question mark icon, type the word comment in the text box and click send, or anyone may raise their hand by clicking once on the hand icon. And if you're on a mobile device, those features may be behind the 3-dot other options. Any comments? I do not see any requests for comment. Shall I close that feature?
Thank you.
You're welcome.
Board Secretary, please call the roll. Board Secretary, please call the roll and reread. You have to reread that. I'm sorry. Put that into the motion.
Okay, the motion is to submit to the California legislator in the board sunset review report a recommendation to add section 1646.12 to article 2.75 and section 1647.35, 1647.36, and 1647.37 to article 2.87, amend section 1646.1, 1646.2, and 1646.9 of article 2.75, section 1647.2 and 1647.3 of article 2.84, section 1647.18, 1647.19, 1647.20, and 1647.22 of article 2.86, section 1647.35 and section 1647.36 of article 2.87, and section 1724 of article 6 of chapter 4, and repeal section 2079 of article 3 of chapter 5 of subdivision 2 of the Business and Professions Code.
Thank you. Do you want to do that one more time, or should we take the vote?
I'm going to call the roll. Chan?
Chan, aye.
Chan, aye. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, aye. Forge?
Forge, aye.
Forge, aye. Ladine, aye. McKenzie?
Kenzie, yes.
McKenzie, yes. Medina?
Medina, aye.
Medina, aye. Molina?
Molina, aye.
Molina, aye. Olage?
Olagi, aye.
Olage, aye. Pacheco?
Pacheco, aye.
Pacheco, aye. Thakur? Thakur, aye. You?
You, aye.
You, aye. Motion passes.
Thank you very much. A lot of motion there. We have 22E is next. This is an agenda item that discusses, to look at a discussion and possible action on a legislative proposal to amend Business and Professions Code Section 1700 regarding display of license. Mr. Bergman, continue on, please.
Thank you, President Felsenfeld. This specific proposal is being brought to the board because of questions that have been brought to board staff from licenses that indicate that some clarity about the requirements for the display of license in the office are necessary. Business and Professions Code, Section 1700C, specifically requires the person, company, or association that engages in the practice of dentistry to cause to be displayed in a conspicuous place in his or her office the name of each and every person employed there in the practice of dentistry. So the specific proposal would provide some additional clarity to that language, and you can find what we are proposing on page 200 of your meeting materials. We are recommending that the subdivision be revised to read as follows, that the way this section is constructed, the violations are by not doing something. And so the specific language here would be that the dentist would have to display in an area that is likely to be seen by all patients who use the facility, original or copy of the current license, permit, or registration of each and every person employed at that facility to practice dentistry. So we're two basic changes here that we're being specific about having the display in a place where all patients who use the facility are likely to see it. And then also specifying that the information to be displayed is specific to those employed there to practice dentistry. And this is, the language that we're using here is consistent with the language in BPC section 1658.1, which concerns the display of documentation related to the additional office locations. So as before, we have some suggested motion language should the board wish to make some changes to the proposal or not. And if the board opts not to take action at this time, then the language would remain as currently written.
Thank you, Mr. Bruggeman. Is there any board discussion or questions? Dr. Chan and then Dr. Yu.
Good morning, David. The question that is posed, the language says, the proposal of the language says, everyone. It doesn't say licensed.
As it's currently written, that is true.
Dr. Yu. Microphone, please, and or get it close.
Okay, just want to move to include in the board's sunset review report a recommendation to the California State Legislature, a legislative proposal to amend BPC section 1700, subdivision C to clarify requirements for displacing the name of everyone employed in the practice of dentistry at the office.
Thank you for the motion then. One moment. You can, but Ms. Medina, do you want to second that? All right, Ms. Medina. All right. There is board discussion at this point. Dr. Thakur,
So when we say,
keep it close, please, so we can hear you.
so when we say that it is everyone who practices, I just want to clarify that it is dentists, hygienists, assistants, everyone.
So the practice of dentistry has a specific definition in statute, and I'll defer to board counsel on this point, that this would specifically be restricted to dentists.
We're getting the code. Hang on.
Well, the current language in statute is in C, subdivision C. And we're just trying to clarify what the conspicuous place is, and that would be a place in the facility likely to be seen by all patients. The name, and instead of just the name of the individuals employed to practice dentistry, we're clarifying that it's not just the name, it's the original or copy of the current license, permit, or registration of each and every person employed at the facility to practice dentistry. So a dental assistant who does not have a permit or registration to practice dentistry, because they're not required to, wouldn't have to display anything because they don't have anything to display. This actually clarifies it, and then perhaps before, if a dental assistant was performing acts that could be considered the practice of dentistry but do not require a registration, they would have had to display their name. But this changes that so that it's just the individuals practicing dentistry who have been issued a license, permit, or registration.
Strictly dentist is what I'm getting. Yes, thank you. Any other board questions? Now, we have the motion before us. Any other board questions on the motion? Is there any public comment on the motion from those who are here in the room? Seeing none, is there any public comment from the WebEx participants? DCA moderator, please open it up for comments from the WebEx group.
Certainly, we've opened up the WebEx Q&A to facilitate public comment. If you've got a comment on the motion, you can click on the question mark icon, type the word comment and click send, or you may raise your hand by clicking once on the hand icon. And the hand icon might be behind the three dot other options if you are logged in on a mobile device. I do not see any requests for comment. Shall I close the public comment feature?
Please do.
Thank you.
Thank you. Board Secretary, would you please reread the motion and take the roll?
The motion is to include in the board sunset review report a recommendation to the California State Legislature, a legislative proposal to amend BPC Section 1700 Subdivision C to clarify requirements for displaying the name of everyone employed in the practice of dentistry at an office. I'll call the roll. Chan?
Chan, aye.
Chan, aye. Felsenfeld?
Felsenfeld, aye.
Aye. Forge?
Forge, aye.
Forge, aye. Ladine, aye. McKenzie?
Kenzie, yes.
McKenzie, yes. Medina?
Medina, aye.
Aye. Molina?
Molina, aye.
Molina, aye. Olage?
Olagi, aye.
Olage, aye. Pacheco?
Pacheco, aye.
Pacheco, aye. Thakur? Thakur, aye. You?
UI.
You, aye. Motion passes.
Thank you, Board Secretary. Dr. Montez would like to comment.
Good morning. I would just like to thank the board for moving this forward. Again, as David stated, this was an issue brought to our attention by our special investigators. And so, again, this, I think, validates the communication amongst board staff for recognizing concerns and how to better address their investigations, both for licensees and both for staff. So thank you.
Thank you. We now move on to discussion item number 22F, which is a discussion and possible action on a legislative proposal to repeal Business and Professions Code Section 1607 regarding frequency and location of board meetings. Mr. Bergerman.
Thank you, President Felsenfeld. This specific proposal addresses where the board is obligated to hold its meetings and how often under state law. Business and Professions Code Section 1607 requires the board to hold meetings regularly once each year in the San Francisco Bay Area and once each year in Southern California, and at such other times and places as the board may designate for the purpose of transacting its business. The section was last amended by Assembly Bill 1519 in 2019 to change the previous requirement that would hold meetings in the Los Angeles area to now require meetings to be held in Southern California. Our legislative proposal, and based on the issues related to the COVID-19 pandemic, obviously we have not been able to meet as instructed in statute over the last several years. But given the time that we are essentially restoring normal practice, we are bringing to the board the notion that we should repeal this section so that we have a little more flexibility in where and how frequently the board may hold those meetings. If we were to repeal this specific requirement, what would then take precedent is Business and Professions Code Section 101.7. And that requires all Department of Consumer Affairs boards, absent other provisions of law, to meet at least 2 times in each calendar year, once in Northern California and once in Southern California. This section would also allow the director of the department to exempt any board from these meeting requirements upon a showing of good cause. So by repealing the section 1607, this would be essentially the requirement under law that the board would have to face.
And therefore easier for us to plan meetings, I'm guessing. So,
Exactly.
okay, thank you. Is there any board member or executive officer conversation on this? Executive officer, you're welcome to comment.
Thank you. Again, I just want to reinforce, as David stated, that this gives us more flexibility. We still anticipate meeting quarterly, but with technology now allowing us to have our public attend virtually, it gives us just tremendous flexibility. So we want to be wise in use of our fiscal resources and going and traveling and doing various things. So we want, again, to keep the access, but we also want the flexibility and being fiscally resourceful. Thank you.
Thank you. Is there any other board member discussion on this? We would like to hear a motion. Ms.
I'm ready to
Alagi,
make a motion. I'm ready to make a motion.
you're making the motion?
Yes.
Read it. Sorry,
So,
we have to do that.
yes, the motion is to move to include in the board sunset review report a recommendation to the California State Legislature of the legislative proposal to repeal BPC section 1607.
And thank you, Ms. Alagi.
Olagi, second.
Thank you. Is there any further board member discussion? Seeing none, we will open it up for public comment. Is there any public comment from those here in the facility with us? Seeing none, we'll ask the DCA moderator to open up the WebEx for those who are participating via WebEx.
Certainly, and we've opened up the WebEx Q&A feature to facilitate public comment. If you have a comment on the motion, you can click on the question mark icon, type the word comment and click send, or anyone may raise their hand by clicking on the hand icon. Are there any comments on the motion? I do not see any requests for public comment. Shall I close public comment?
Please do.
Thank you.
Board Secretary, would you please restate the motion and take the vote?
The motion is to include in the board sunset review report a recommendation to the California State Legislature of the legislative proposal to repeal BPC section 1607. I will now call the roll. Chan?
Chan, I.
Chan, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Larin, I. McKenzie? McKenzie, yes. Medina?
Medina, aye.
Medina, I. Molina?
Molina, aye.
Molina, I. Olage?
Olagi, aye.
Olage, I. Pacheco?
Pacheco, aye.
Pacheco, I. Thakur? Thakur, I. You?
UI.
You, I. Motion passes.
Thank you. We now move on. I have a little confusion in my mind, and we did 24 yesterday.
That's correct.
We need to do 23 today.
Yes, we did.
Thank you.
Yes,
Because
and
then we'll go to 23A, which is the status on updating pending regulations.
Yes.
Thank you, Mr. Bruggeman.
Yes, so in your media materials, you will see the update that I'm going to briefly summarize. We've got the narrative section discusses those packages which have moved since the last board meeting. And then the chart simply outlines those other packages that the board is focused on, but there has not been specific motion forward since the November meeting. So there are three packages worth noting. Our vaccine package, which implements permanent regulations concerning dentists initiating and administering vaccinations. That package was submitted to the Office of Administrative Law on December 16th, and it was approved by the Office of Administrative Law and filed with the Secretary of State on January 24th. So the emergency regulations that had been in effect have been substituted by the permanent regulations. Additionally, the package concerning temporary licensure for military spouses and partners, this is connected with AB 107. Board staff have been diligently revising the package in light of the new language that was approved at the November board meeting. We anticipate being able to file with the department by the end of the month, hopefully getting it noticed in March. And then finally, and this is actually item 23B, the updates to the board's disciplinary guidelines. This is a new package. We have a proposed updates to the disciplinary guidelines and to the language which incorporates those guidelines into our regulations as item 23B. And so that's the extent of my report on 23A.
Thank you. We're going to consider 23B by itself in a moment. So are there any board member comments about 23A to the point of 23B prior to? Seeing none, there's no action required, so we're going to ask if there's any comment from the people in the facility who are public and coming. Comments? None. Will the DCA moderator please open up the microphones for public comment from those participating via WebEx?
Certainly, and we've opened up the WebEx Q&A feature to facilitate public comment. If you have a comment, you can click on the question mark icon, type the word comment in that text box and click send, or anyone may raise their hand to ask to comment. Each person will have 2 minutes to speak. I see no requests for comment. Shall I close the public comment feature?
Please do.
Thank you.
Thank you, moderator. We now move on to. Thank you. We now move on to, or not, to item 23B, a discussion and possible action to initiate a rulemaking and amend the California Code of Regulations, Title 16, Section 1018 on disciplinary guidelines. Mr. Bruggeman, please continue. And
Thank
we
you,
have a
President.
special, there was an added handout. It's not in the
Yes.
main agenda, there's a secondary one. So if you don't have it, that's what you need to look at.
So for members of the public, this was an item posted separately on our website. You can still find it on our meeting calendar. This is agenda item 23B. So the disciplinary guidelines that the Dental Board of California utilizes were last updated in 2010. So obviously, there have been significant changes to laws and regulations and in the administration of various penalties for violations that would require the use of the guidelines. The proposed amendments for the guidelines are going to make them consistent with changes with current law and with the current probationary environment. Their changes are also going to help clarify terms and conditions of probation to reduce the possibility for misinterpretation and to ensure that we continue to protect the public and consumers to the best of our abilities. The specific regulatory language that we are speaking about is brief, but the package that we would submit to the Office of Administrative Law does include the text of the guidelines, and those are relatively lengthy. The specific regulatory changes we're making can be found in the first attachment following the memo. In most cases, the changes are simply to reflect the update of the addition date of the guidelines to revise the title. We are now proposing that the guidelines be called the Dental Board of California Disciplinary and Denial Guidelines with model language. And we are also adding some additional language in section 1018 subdivision A that we're inserting or aggravating after mitigating in the last sentence. But the changes of most interest here are to the guidelines themselves. I'm going to briefly, quote unquote, briefly summarize those changes. There are obviously going to be non-substantive changes throughout the document, but there are other significant changes that are being made as follows. As I mentioned previously, we're inserting "and denial" into the title of the guidelines, and this is to address those statutes that would concern the denials of applications. Denials of applications are not considered discipline, and so we want to be clear in that perspective in our guidelines moving forward. The changes will also establish criteria for when to use the board's approved uniform standards related to substance abuse and licensees with standard language for probationary terms and conditions, commonly referred to as the uniform standards. Throughout the document, we are going to be adding the words terms and before conditions. So we're looking to probationary terms and conditions would be the consistent usage there. And again, we're reflecting changes to California law made since the last update. This would include the adoption of the substantially related criteria and rehabilitation criteria outlined in our regulations in 16 CCR sections 1019 and 1020, and required by the Business and Profession Code sections 480, 481, and 482. You may remember references to AB 2138. These are the specific provisions of statute and regulation connected to that. We're going to add a term, disclosure of probation status to patients, and with an accompanying rationale to the list of standard probationary terms and conditions. And this is required for, this specific term is going to be required pursuant to BPC section 1673, only for probationers that meet specific criteria. This would include the commission of any act of sexual abuse, misconduct, or relations with a patient or client. And this term reflects the requirements of that section of our law that has been updated since the last time the guidelines were implemented. So we are also going to rename the term 6 on our standard probationary terms and conditions list It's currently referred to as status of residency, practice, or licensure outside of the state. It's now going to be called tolling of probationary period. And that is because we are also removing term 11, currently called function as a licensee, from the list of standard probationary terms and moving provisions of that term into term 6, the tolling of probationary period term. The term function of licensee typically refers to the ability of the licensee to fulfill the functions of their job as a dentist. And we're incorporating that into the provisions which affect how the probationary period is tolled or suspended, given the ability of the licensee to practice, which is a condition of their probation. We're going to be adding term 15, the civil penalty and rationale, to the list of the standard probationary terms and conditions, because this penalty is required when a respondent fails or refuses to comply with a request for patient dental records, or fails to or refuse to comply with a court order mandating the release of records pursuant to California law. The updates also add modeled introductory language for all disciplinary orders, adds notes to the standard terms section indicating that the standards will apply for substance abusing licensees. And we're going to add language to, excuse me, I'm just going to take a moment here to pause. Does anybody have questions on what I've covered so far? I've got a little bit more to go.
Okay, we could stop for a moment if anyone does have any questions, Mr. Bruggeman. There's a lot of information in here, obviously. I'm not seeing any from the board, so why don't you continue on till we can get to the point where we can open it up for discussion.
All right, the updates add clarifying language to standard term 1, which is obey all laws. It's going to expand the rationale in that term to cover the discipline from other boards and agencies. We're striking redundant and unnecessary language on license restoration from term 3, which is comply with the board's probation program, and adding additional rationale language to that term. Also adding language to term 4.
Mr. Bruggeman?
Yes.
Excuse me for one moment for interrupting, although I tend to interrupt a lot.
No,
If you're comfortable, the board has had an opportunity, this is the 3 pages of clarification and
yes, I
change. You don't
understand.
necessarily have
If
to
we-
read that to us. That would be a lot of reading. We've all had an opportunity to read it, to be sure. So if there are no questions about that, I think we can move on to the back end. Oh, I'm sorry, Ms. Welch, sorry.
So I think for efficiency's sake, we're just referring the public and the members to the meeting materials that explains all of the changes and includes the language. But for sake of the transcript and meeting minutes, I would like to check in with the board's regulatory counsel, Christy Shields, to see if she would, if she has any concerns about not discussing on the record each change. Christy, can you comment?
Good morning. This is Christy Shields, the board's regulatory counsel. I do not. We can simply refer the members to the materials, but we did have one proposed suggested amendment that we want the board to consider to the text that you have in front of you. So President Felsenfeld, do you want us to discuss that, or do you want to open up for board questions or comments on other items?
I think the board has not had questions about this to date. I think if you want to tell us what your proposed amendment is, that would be important for us,
I can
please. Wait.
certainly move to that portion of the conversation.
Okay.
So,
All right.
Thank you.
Ms. Shields, could you bear with us for one moment?
Sure.
so I'm aware
You're
of the change.
pretty much done with your report, with the exception of going through each of the items. Is that correct, Mr. Bruggeman, or? What's that?
So
You have,
I know the change.
oh, you know the change.
Yeah, I know the change that Council Shields is referring to. I can certainly discuss that right now if everybody is clear in terms of maintaining the record appropriately.
Let's
in the
ask
contract.
Ms. Shields to discuss it first, and then we'll pick it up from there. That way we can let her do what she has to do, and I'm sure she has other things she's doing today as well. Ms. Shields, would you like to discuss what your suggested amendment would be?
Sure. Sure. So if we can go to page 27 of the materials, which would be.
This is going to be page 27 of the guidelines.
Yes. So on the website link though, Mr. Bruggeman, is it page 27 though? No, I think it's page 39.
That would
So if
make
you look
sense.
at page 39 of the electronic materials, the scanned agenda item, at the top, you'll see the term for examination. This is a term we typically use for people that are having difficulty or showing issues with competency, for maintaining minimum competency. It requires the respondent to take a specific examination as part of probation or maybe for a petition for reinstatement. And so the staff had originally suggested that they include, that the board include or other state, regional, or national examination the board accepts for licensure. And I would suggest striking the words or other state, comma, regional or national, and also the board accepts for licensure, because the law can be vague, but regulations, the purpose of a regulation is to make specific what the law leaves unclear. And the board currently does not recognize any other state, regional, or national exam except for REB, which we all know is going to be phased out by the end of this year, and ADEX. And so specifically what the exams that would be required for a probationer or a petitioner for reinstatement to take would be the ADEX, because we want to look at what we would implement in the foreseeable future, what we know currently exists in law, and what we can defend to the Office of Administrative Law. So I would recommend striking that language, and so that the actual phrase would read that respondent shall not practice dentistry until respondent has passed the American Board of Dental Examiners open paren, ADEX, close paren, examination, instead of what is written here.
So the amendment would be to eliminate the words or other state, regional, or national.
And the
correct?
board accepts for
In addition,
licensure.
you are also, the recommendation is also to strike the phrase, the board accepts for licensure at the
Yes.
end of that sentence.
Right. So that it would just say American
So that
Board of
and
Dental
then
Examiners
respondent, okay.
examination. Yes.
Okay, is there further, Ms. Welsh, do you want to comment on that, or?
No, it seemed like Christy was trying to speak. Christy, just so you know, we have to turn the volume down on the WebEx every time the board or David speaks because we're getting feedback. So I'm trying to keep an eye on the WebEx to see when your microphone pops up so we can hear you. We have to turn the volume up on the WebEx to hear you. So did you have any additional comments for the board?
No, thank you.
Looks like no.
Ms. Shields, are you there?
Yes.
Do you have additional comments?
No, I guess you didn't hear. No, I do not, but that was my recommendation. And if there are no other proposed changes, we have a revised motion that we can read into the record. Mr. Bruggeman, I believe, has prepared. So
So if I am, anything else? I'm sorry, Ms. Shields.
no,
All right, so if I am clear on this, in what we're reading, after the parenthetical ADEX, there's a period and nothing else until the next sentence that says respondent shall pay all fees. Is that correct?
yes.
Oh, ADEX examination. Okay, that's fine. Thank you. All right. Okay, Ms. Shields, thank you. We're good. And if you want to go back to your other work, that would be great. And Mr. Bruggeman does have that language as well, so we're good to go.
So because we are recommending a change, the motion language that we are suggesting is motion B. It would to incorporate the specific change and any other changes to the guidelines or to the regulatory language that the board would decide to move forward with.
Okay. I think we're at a point where we can
Sorry.
consider
excuse me.
this as an amendment and we can vote this in or not as an amendment to this. Dr. Chan, did you, and let's discuss that part of it, whether we want to amend this document, okay? Dr. Chan, did you want to comment on that?
I have a point of inquiry. I couldn't find it in the document, but is it appropriate to have a section that talks about a petition to terminate probation?
Let's hold off on that. We're
Okay.
talking about the amendment specifically. That'll come up in a minute.
Okay.
You're welcome to ask that. Let's deal with this as an amendment to the document. All right, so Is there any discussion about the potential for this amendment? Any comments on it? What we should do, I'm sorry, there's
Yes.
someone over there, Wilbert? I can't hear you.
This is the
Christie,
moderator.
Ms. Shields,
Ms.
you're back
Shields,
there, sorry.
yes.
So again, we have prepared language if there is no other change, but if there are other changes, we will hold off until we make, I'll hold off in making that recommendation until I hear from the members. Thank you.
I'm sorry, I didn't understand that. Did you?
So with respect to Dr. Chan's comment, I think you were proposing to add motion or a specific order language like we have proposed to add for petitions for reinstatement. I think that's it. We don't have language to present to you for petitions for termination or modification. We were, this thing is so large and monstrous that I basically popped in language that I had used for other board disciplinary guidelines. We don't have ready and easy language for the modifications because if they can request termination, but the board may change that request to grant partially and deny partially to change the order so that the petition is granted in part with modified terms. So because of all of the different variables for those types of petitions, we don't have standard language included in the disciplinary guidelines for you.
The question was whether or not it was appropriate, first of all. And then it would help guide us as we move forward and we see these petitions to terminate. Give us some idea where we're going with those. And that was the genesis of the question, if it was appropriate.
I don't think it's necessary. Everything that we're doing with these regulatory changes needs to be justified. And because of the variables, it would be difficult to craft standard language to be used in those orders. So for petitions for termination or modification, ALJs typically have language that they can, utilize for those proposed decisions on that. And then otherwise it would be a stipulated settlement. Those are the only two documents that you would review as the board for those types of petitions. So we're just saying that we can't really craft standard language. So we're not including it here.
So noted.
You're okay with that? So let's go back to where we were. We jumped the gun on this. We were still looking at the modification or amendment of this particular document to eliminate the words "or other state, regional, or national, the Western Regional Examination," leaving the word examination in there, the board accepts for licensure. That's where we are. Does anyone want to propose that as an amendment to this document?
Pacheco to propose the change.
Propose striking all those words, leaving the word examination in there, and then go back to respondent shall pay. Okay. Who would like to second that? Anybody want to second that? I see Ms. Ford's hands went up. Rupert from Bauer, Wilbert Rubauer. Ms. Shields. Ms. Shields, go ahead.
Oh, can you hear me now?
We can.
Okay, great. So my suggested motion would be to approve the proposed regulatory text for section 1018 and incorporated guidelines with the following change on page 27 of the first sentence of the optional term examination. Remove the words "or other state, regional, or national," and "the board accepts for licensure," so that the sentence would read, "Respondent shall not practice dentistry until respondent has passed the American Board of Dental Examiners," in parentheses, ADEX examination, period. In addition, submit the approved text to the Director of the Department of Consumer Affairs and the Business, Consumer Service, and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the text and the package, and set the matter for a hearing if requested. If after the 45-day public comment period, no adverse comments are received and no public hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations as noticed for 16 CCR Section 1018.
Stand down for just one moment. We have a little technical question here.
All the way down.
Okay, thank you. I'm sorry about the delay. Okay, so we have, now, within the amendment, Ms. Shields just added a series of language in there that relates to standard language relative to we can do whatever we have to do. Do you want to see that in the language in this particular paragraph under examination? Is that, I'm asking Ms. Shields that, or is there a place to put this at the back end of this? Because all of
So
it is going to relate to
the
that.
specific language changes he described, if you look at them in the memo on motion B, it would be inserted into the parenthetical that currently reads, describe the proposed changes to the proposed text. So that is, the text change language that she indicated, it would be what would be described. Yeah. So the motion would be to approve the proposed regulatory checks text for section 1018 and incorporated guidelines with the following changes.
All right, we have not made these changes. That's the whole point
Right.
I'm trying to make. We, Dr. Montes.
So, Dr. Felsenfeld would like to see two motions made. One, to accept the changes, and then two, to accept the overall guidelines as presented with the amendment. So to focus everybody's attention, we're just on this amendment. We need the board to accept that, someone to make a motion, and then move forward.
I was about to go there, but yes, we can't say to accept it as amended unless we amend it. That's the whole point from a parliamentary standpoint. We have an amendment before us. I will make the motion since it's unclear, or did we already make the motion? I don't think so. I think, did you make? We attempted to. All right, well, Ms. Pacheco, why don't you give us the amendment, and this is what Ms. Shields wants, and this is the right thing to do. I see this, that's my personal opinion. Go ahead.
So the motion is to accept the amended language.
Which is to eliminate, you have to tell them what it is.
Okay.
Make sure it's clear, because that's what we're going to vote on. Here. Right.
Thank you. Okay.
To accept the amendment on page 27, just read the rest of that.
Okay, to accept the amendment on page 27 of the first sentence of the optional team examination, remove the words "or other state, regional, or national," and the board accepts for licensure, so that the sentence would read, respondent shall not practice dentistry until respondent has passed the American Board of Dental Examiners ADEX examination.
That is a proper amendment, and it's been seconded by George, we sort of did that before. Okay, and so we're going to look at this amendment, and then we're not going to jump to the end till we're ready to do that, which might be right after this. We don't need public comment on the amendment. This is an internal document we're modifying, so we can go right to the vote.
Right to the vote. Okay, Chan, aye.
And I.
Felsenfeld, aye.
Felsenfeld, aye, yes, you knew that.
Ford, aye.
Ford, aye.
Larin, aye. McKenzie, aye. No, sorry. McKenzie, yes. McKenzie, yes. Medina,
Medina, aye.
Medina, aye. Molina,
Molina, aye.
Molina, aye. Olage,
Olagi, aye.
Olage, aye. Pacheco,
Pacheco, aye.
Pacheco, aye. Thakur, aye. You
UI.
aye. Motion passes.
Thank you. We now have an amended document to be considered. You have to do this, keep it clean so everybody knows what they're doing. You now have an amended document to be considered. And do you have any more that you would like to add, Mr. Bruggeman?
We've already addressed the only change that the board
Okay.
staff has for this.
Okay, so within that and the extra language that Ms. Shields had given us is at the bottom, is in the actual motion, if I'm not mistaken, which is on page, I can't find the motion now because it's on, is the motion's in this amended document too,
In the
right?
amended document, it would be page 6.
Page 6, all right, thank you. Let me take a look at it. Make sure we're doing the right thing. Here we go. Okay, so we are now going to look at, I imagine, motion B, and that would be with the amended document. Is there any discussion? Do you want to make, I'll make the motion to put it up on the table for us. I want to approve the proposed regulatory text for section 1018 and incorporated guidelines with the following changes, and the changes are as listed over the 3 pages in the front. We're not going to read every one of those. They're in there. In addition, we'll submit the approved text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the text and the package, and set the matter for a hearing if requested. If after the 45-day public comment period, no adverse comments are received and no public hearing is requested, will authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations as noticed in 16 CCR section 1018. That is the motion. And Ms. Medina is going to second that. Thank you. Is there any board member discussion? I'm sorry, Ms. Welch.
I just want to clarify that the changes that you were referencing in your motion, that is the bulleted changes in the memo, is not the described proposed changes that you've made today, which is the last motion you just made to just amend page 27. So this motion is approve the regulatory text, which is all of the changes in the memo, plus with the following changes that was read off by Ms. Pacheco to page 27, those
Correct.
amendments.
The amended document, it's all of the changes that we see before us, all 85 pages, with the one amendment that we made today. That's what we're talking about. Okay, is there any further clarification or discussion on the behalf of the board? Thank you. Is there any public comment from people in the audience? Seeing none, is there any public comment from people participating via WebEx? Moderator, please facilitate public comment via WebEx.
Certainly. And we've opened up the WebEx Q&A to facilitate public comment. If you'd like to make a comment on the motion, you can click on the question mark icon, type the word comment in the text box and click send, or anyone may raise their hand by clicking once on the hand icon. Are there any questions on the motion? I do not see any questions. Shall I close the public comment feature?
Please do.
Thank you.
Okay. Board Secretary, ready to take the vote? I think what we can do to make sure that we're comfortable is when we can read it back saying the proposed regulatory text as amended. And that will include everything and including the amendment. Would that be okay from a legal standpoint?
Right, as amended at this meeting.
At this meeting, that's perfectly fine. All right, Dr. Lorien, please reread that and then you can take the vote. And I'll make sure we do the same things. Go ahead.
Approve the proposed regulatory text for section 1018 as amended and incorporated guidelines.
As amended at this meeting.
At this meeting and incorporated guidelines with the following, eliminate that.
Yeah.
In addition, submit the approved text to the Director of the Department of Consumer Affairs and Business, Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the text and package, and set the matter for the hearing if requested. If after the 45-day public comment period, no adverse comments are received and no public hearing is requested, authorize the executive director to take all steps necessary to complete the rulemaking and adopt the proposed regulations as notified for 16 CCR Section 1018. Okay, we'll take the vote. Chan?
Chan, I.
Chan, I. Felsenfeld?
Felsenfeld, aye.
Felsenfeld, I. Forge?
Forge, aye.
Forge, I. Larin, I. McKenzie?
Kenzie, yes.
McKenzie, yes. Medina?
Medina, I.
Medina, I. Molina?
Molina, I.
Molina, I. Olage?
Olagi, aye.
Olage, I. Pacheco?
Pacheco, aye.
Pacheco, I. Thakur? Thakur, I. You?
UI.
You, I. Motion passes.
Thank you. Yesterday, you guys were kind enough to allow us to put item 24 up there so we could get that done. And now we're going to go to item 25, which will be, as soon as I can get to it in my script, will be the discussion of prospective legislative proposals. Mr. Bruggeman.
Thank you, President Felsenfeld. This is the reminder to the public and other stakeholders that you're encouraged to submit proposed legislative proposals to the board before, during, or after any board meeting, and they would be subject to consideration at a future board meeting. Anything that would be submitted at this meeting, for instance, would not be able to be acted on until it could be placed on the agenda of a subsequent board meeting.
Any board member discussion? Is there any public comment from people here? Dr. Leal? Well, please come up and do. You're welcome to 2 minutes. You may leave that there, and if we need to look at, what is this for now? This part of your comment? You can pass it out, sure. Yeah. Just leave it and we'll deal with it. All right. We're certainly not gonna be able to read that now. Give it to Morella and we'll distribute that. Thank you. All right, you have 2 minutes, sir. Go.
Members, President Felsenfeld, as I indicated to you yesterday, we're very concerned about the current state law that essentially requires Moldova and any foreign school to be accredited via quota. The documents that you're going to have before you are accumulation of documents that tell you how extensive, complicated quota is. Timeline is 10 to 12 years. And it's difficult, if not impossible, for quota to achieve the mandate by January 2024. I also included some supporting documents from parents and students and stakeholders promoting the program. Now, this is the time for legislative proposals. So in there, I provided 4 options. The first option is you may consider reverting back to what it used to be, that this board take the responsibility of evaluating foreign dental schools and do it in-house and create a system like you did with Moldova and La Salle. The other option is that you take the 2 schools, which is La Salle and Moldova, the only 2 schools that have been accredited historically, and grandfather them in, because to subject them to start over through quota is extremely difficult. The documents I provided to you show that La Salle went through quota, took about 11 years, and was denied. Expensive, lengthy, difficult. Your third option is if quota is a true commitment from this board, which I'm not in favor of, then we need more time. We just need more time to ensure that we go through the process. I can assure you it's not 3, 5, 7, it is 10 to 12 years. And the last option really relates to, it's more legal than anything else. I found in your legislation a sentence that intrigued me. It said that the board can essentially identify an accrediting body that you can choose for approval purposes. That would keep it in California. So the documents you have at page 2 provide those 4 options. I'm requesting that they be put forward in your sunset review session or in some fashion.
Thank you, Dr. Leal. Time is up.
Thank you, sir.
Dr. Montez.
Yes, and I would just like to clarify for the record that I had recommended or suggested that Dr. Leal make his 2-minute presentation and then to provide any written documents to board staff for consideration for a future board meeting. So it has been given to board staff for the next steps. Thank you.
Okay. I am hopeful that it is the board who will receive the documents.
Ultimately, the board will consider, but staff has to work through it. Thank you very much, Dr. Leal. Well,
I have a comment.
Yes, Dr. Molina.
Um, as you all know, I have a daughter that is in Moldova Dental
We
School
can't discuss this.
who's graduating in June.
Dr. Molina, I'm sorry. I am terribly sorry. We can't have a discussion about this here right now. It's inappropriate. It's public comment, and then we deal with it after the fact. So I understand you have issues, but we can't deal with that today. It's not agendized.
Okay,
Okay.
so, but earlier you had said, are there any board comments?
Yes, I asked you earlier. And you, we can't get into a discussion on this.
Maybe I should let legal clarify, but it is comments about proposals.
Yes, for the
Not
future.
in response to proposals. So if the board members had potential proposals to bring forward, that would be the board comment that would be offered. So we are not responding to proposals discussed here.
I am not responding, I have a proposal.
What is that?
Okay, so.
We will hear that.
Continue, yes.
You're done, Dr. Leal. Thank you.
Thank you.
Let me continue. So she's in Moldova Dental School and is graduating in June. I personally know the value of this program, and I'm concerned that the requirements of quota accreditation may result in the termination of this program. The creation of these schools was intended to address the shortage of dentists, especially in underserved communities. I request we take a serious look at this issue. We have new members that may not be familiar with the history, so a thorough review should be done with the objectives of having both Moldova and La Salle continue as our two approved dental schools. The board had already evaluated them and approved them. If future schools apply, CODA can accredit them, but for these two schools that have a proven record of training great dentists, we should work with them to do what this board did in the past and approve them. Mr. President and the board, I would like to make a motion that we analyze and look into the process.
Not appropriate at this
accrediting-
point. Not appropriate to make a motion. You're putting things on the table for us to look at, and we will address that as through staff and back to the board.
Okay, thank you.
Thank you. That's all. Thank you, Dr. Molina. Well, is there, yes, please. Did you want, is there any additional public comment on anything perspective? Does not seem to be. And how about through WebEx?
This is
BCA
the
moderator, would you
moderator.
please facilitate public comment on the proposed legislative issues?
Certainly. If anyone would like to make a comment, they can click on the question mark icon, type the word comment, and click send, or raise their hand. Each speaker will have 2 minutes to speak. Are there any comments? I do not see any requests for public comment. Shall I close that feature?
Thank you. Please do. Well, thank you, board members, moderator and board staff, and the public attendees for your assistance and participation in the meeting today. The February 9th to 10th, 2023 Quarterly Dental Board Meeting is adjourned. Thank you.